All right, let's now get some reaction from the Public Protector's Office. Muntu Sithole is with the legal services at the Public Protector's Office. Muntu, thank you so much for your time on the lead. Another blow for the Public Protector. What's her reaction to the judgment?
Hi, Clement. Well, of course, Clement, we were hoping for a positive outcome, an outcome that favors our report. But unfortunately, the court had a different view than ours. And because it's the Constitutional Court, we have to accept the judgment and take out lessons that can help us in conducting our investigations going forward, because obviously we can't appeal the judgment of the Constitutional Court.
This judgment is quite scathing, Muntu. Like many other judgments, the majority judgment says the Public Protector didn't have the facts to support her judgment. She twisted the words of the Executive Ethics Act to support her findings. In fact, the wording in that judgment is she misconstrued the code. The judgment says her reasoning is devoid of legal foundation. This is not the first time that the Apex Court questions her understanding of the law. This is serious. It makes people question whether she's up to the task.
Yes, of course, Clement, the Constitutional Court is entitled to criticize the Public Protector in the manner that they deem fit. But what happened here is that actually the Public Protector did not change the wording of the code. There is two codes that regulate the executive members' conduct. And one code is contained in the Ministerial Handbook, and it was approved by Cabinet in 2007. That is the code that contains the words inadvertently and deliberately. And that is the very same code that the former Public Protector relied on in her investigation in the Nkandla judgment. It's the very same code that was relied on when the former Minister Dinapule was investigated by the former PP. So it cannot be that the Public Protector went out of her way to create words that are non-existent in statute. She relied on the code that is there, that was approved by the Cabinet in 2007. Now you have a code that is promulgated in 2000 that has the words willfully. And the two codes are actually the law, because they guide the members of the executive in how they conduct their affairs. And the Public Protector relied on the code of 2007, which was relied on actually by the same Constitutional Court in the Nkandla judgment.
So you are saying that what the Constitutional Court has failed to do is look at the code which the Public Protector relied on. The Public Protector didn't necessarily rely on the code that the Constitutional Court was looking at. And maybe you can help me here. Which code is that? Is it the provisions of paragraph 2.3a of the Executive Ethics Code?
Yes, Clement. Clement, both codes are the same. Funny enough, the only difference is in the words willfully, and the other code is inadvertently and deliberately. That's the only difference. The rest of the text is the same. And the Public Protector relied on the code that says inadvertently and deliberately. So it cannot be that she changed the code. Possibly, maybe to give the benefit of the doubt to the Constitutional Court, they relied on the code that was before them when the record was filed, and probably did not have the Ministerial Handbook code, which the Public Protector relied on when she conducted an investigation.
So when the complaint was laid by Mkhwebane, did he ask the Public Protector to investigate the President based on this code in the Ministerial Handbook, or based on the executive ethics code that the Constitutional Court relied on?
Clement, once again, it's the same thing. Even the code that you find in the ministerial handbook, it's written the executive code for members of the executive, or Executive Members Ethics Act, which contains the code. And therefore, obviously, the complaint will simply say the president violated the EMEA. We call it EMEA. And therefore, the investigation was conducted on the basis of EMEA, which is contained in the ministerial handbook.
Yeah, just help me understand here, Muntu. I'm trying to understand what the difference is between the two codes, because you keep on saying they are the same, but one says willful, the other one has the wording inadvertently. What is the difference then between the two? Why would the public protector rely on the ministerial code as opposed to what the executive members ethics code, as you say they are the same? Is there a reason why then, even though they are the same with some differences in one word or so, is there a reason why she relied on one and not the other?
There is no specific reason, Clement. This is a legal instrument which has been used by this public protector and the former public protectors. And as I stated, unfortunately, the difference in both the codes is material, in that the code that was relied on by the public protector has these two words, inadvertently and deliberately. And then the code in the act that was promulgated only has the words willfully. It doesn't have the words inadvertently and deliberately.
All right. Let's continue with what the judgment says, Muntu. The minority judgment by Mkhwebane also says that the public protector went overboard in making the supervisory order against the police, the NPA and Parliament. It was wrong for her to conclude that the president misled Parliament and even use the word willful and inadvertent interchangeably when the two are mutually exclusive. That's what the justices agree on, whether it's the Constitutional Court, whether it's the majority or the minority judgment. I want to ask you about the impact that these judgments have on the office of the public protector. There have been judges from the High Court all the way to the Constitutional Court ruling that the public protector is biased, she's dishonest, she's failed to uphold the decorum of the important institution that she serves, that she approached an investigation with a preconceived idea, she lacks the understanding of the law, she made conclusions on discredited reports and unsubstantiated facts. Her reports are vague, they're contradictory, nonsensical, irrational, unconstitutional. Surely when you are described like this, and your reports are described like this, by the judges from the High Court to the Constitutional Court, something is wrong.
She is not the only one who is being described like this. If you look at all the judgments that are decided by these two courts, as long as they involve government, and unfortunately, her institution is the one that gets to be challenged in court, because she issues reports against, you will say, very powerful people. It would have been the same thing if the Auditor General, for example, had the powers that the Public Protector had, or the Commissioner for Human Rights had the same powers that the Public Protector had. They will constantly be in court trying to defend the reports and to defend the law. But unfortunately, she appears to be the only one who is being taken to court, not because she wants to be taken to court, but because she receives complaints, she investigates complaints, she makes findings, issues a report and takes remedial action, and then people who are aggrieved, they are within the law to take her to court. And unfortunately, sometimes the courts have been very harsh in terms of their criticism to her. But for example, on this point that I just stated on the code, there seems to be the glitch on the law about the two codes that say two different things. On the issue of directing the NPA and the Speaker of Parliament, the Constitutional Court in Nkandla said the Public Protector can even direct the manner of implementation of the remedial action. That's the Constitutional Court. The High Court in the state capture judgment said the same thing. They shared the same sentiment that for the public protector's remedial action to be effective, she must be able to direct the manner.
Direct or recommend,
and actually, if you look at the...
Is that to direct or to recommend? And then those various institutions can follow up on the remedies, because that Nkandla judgment indicated that the remedial actions of the public protector are not just mere recommendations, but they are binding. So if you are finding against someone and you recommend that the NPA must look into investigating money laundering, the NPA can't simply ignore that remedial action. They are duty bound to either implement it or challenge it in court. So did that ruling say she can actually direct Parliament to change laws, or direct the NPA to take up an investigation, or recommend, and those various institutions are then duty bound to respond?
No, and definitely she did not direct in the sense that says, NPA, you are going to appoint director DPP so-and-so to be assisted by 2 prosecutors who will then investigate this matter and then take the president to court. No, she simply says investigate within your powers. She can't direct them she can't give them a word-for-word implementation guide to say appoint so-and-so, so-and-so must make sure that they investigate this person.
But that's a directive, Muntu, is it not? When you are saying you must investigate this, and my understanding is there was even a period that you must even respond, or within, I think it was 30 days, and correct me if I'm wrong. That's a directive.
It's a directive, but it's not a directive that takes away your powers to conduct your investigation in the manner that you deem fit. For example, the NPA could have simply said, it won't be possible for us to conduct this investigation within 30 days. We need 100 days. For example, Deputy Chief Justice Zondo has consistently requested extension within which to finalize his commission of inquiry. There is nothing wrong with that. Even the NPA here could have simply said 30 days is not enough, or 100 days is not enough. In fact, we need 2 years. Then that would have been out of the public protector's powers. They determine how they do it. On the speaker could have simply said, look, I want to take this matter to the joint committee, but I want to await the outcome of your review, of the President review application in the Constitutional Court or in the High Court, as the case was at that time. But there is no remedial action that binds anyone to do something. If you don't do it, then you are guilty or you are in contempt of the Public Protector Act. In fact, the NPA could have investigated and came back to say there is no money laundering here, even after a preliminary investigation. There is no way where the Public Protector says President guilty of money laundering.
Yeah, but I suppose the problem is the process there, Muntu. It's not so much that the NPA was almost influenced to investigate, and that investigation to take this or the other way. It's the process. If the public protector is going beyond her bounds and what she is allowed to do, then that is a bit problematic if she goes and makes such directives. I asked about the impact on the office. There's no way you can claim that all of these judgments don't affect the public protector's office. And I hear you say, I mean, she's not the only one who's being referred to like this. I don't remember any former public protector being accused of not understanding the law, of their reports being described as vague, as contradictory, as nonsensical, as irrational, as unconstitutional, saying that the public protector failed to uphold the decorum of the important institution she serves. What impact do these judgments have on the confidence that the public should be having in this important office?
The impact, Clement, can actually be twofold. The first is if you take the judgment as a lesson, then there will not be any impact. But if you take a judgment as a lesson, then the impact is actually positive, because when the investigators receive a complaint that has to do with Executive Members Ethics Act, their first go-to book is going to be today's judgment. So the lessons and the impact is that it's positive for the institution going forward in terms of investigations that must be conducted and that are still being conducted. So we are obviously taking lessons from these judgments. And we must also remember that this matter is actually about the interpretation of the statute, primarily the Executive Members Ethics Act. And you will see that the court itself actually is split on the interpretation, which is to show that in legal circles, it's normal for people to lose in court, just like the public protector loses. There are many legislations that are always taken on review that are declared invalid, that where the court will even go on to say the minister's decision was irrational and nonsensical and all that. I can refer you to those cases if you want me to. But this is that the positive we must take out from this is that the court said this is how we must interpret the Executive Members Ethics Act. That's the duty of the court, to interpret the law for us. And then going forward, we're going to take this judgment as our Bible to say this is how we're going to investigate EMEA matters.
Yeah, and you confirm that the public protector, and this is my last question because I need to get to the ANC presidency spokesman, you confirm that the public protector was using the Executive Members Ethics Act as her instrument in investigating this case. Is that what you confirm?
Yes, it has.
So why are you bringing in then the ministerial code? If the public protector is using that particular act and it speaks about willful, why does she feel the need then to use the ministerial code?
Clement, as I stated, it's the same instrument. The only difference is that the ministerial handbook has the heading outside, ministerial handbook. But when you go to inside the ministerial handbook, then it has the act and the code. That's the only difference.
Okay. I'm struggling to understand that, Muntu, but thank you so much. Thank you for joining us, Muntu. He is with the Public Protector's Legal Services Department, and he says that they're taking lessons from this judgment, and he is arguing there that the Public Protector relied on the ministerial handbook, which has the words inadvertently, and not necessarily the act itself, which has the wording willful.